Hello, everyone, and welcome to today's educational webinar hosted by the International Trade Council. My name is Ron Olasco, and I'm delighted to be your moderator for today's session. Before we start our discussion, let's take care of some quick housekeeping matters. Firstly, can everyone hear me clearly? If you can, please type in yes in the chat box. Can anyone hear the audio? All right, perfect. Thank you. Good morning. Thank you for confirming. Now let's ensure that everyone can see the PowerPoint presentation slide. If you are experiencing any issues with the audio or visual, please let me know in the chat box and I will assist you promptly. So it seems that everything is running smoothly. Just a quick reminder for our attendees, if you have any questions during the presentation, please feel free to type in the question in the Q&A box located in your webinar interface. We'll address as many questions as possible during the Q&A session following the presentation. So without any further ado, let's get started with our today's educational webinar. Our topic for today is Export with Confidence, a deep dive into U.S. Export Administration Regulations guidelines. We're excited to dive into some essential topics, including an introduction to U.S. Export Administration Regulations, key compliance best practices, and strategies for navigating international markets. We'll also explore practical EAR guidelines through case studies and discuss how to build strong compliance culture within organization. Whether you are new to export controls or looking to enhance your current practices, today's session will provide valuable insight to help you succeed. So let's get started, and please join me in welcoming our speaker, Safak Herdem, Managing Director of Herdem Attorney at Law. Go ahead, sir.
Thank you, Ron. Thank you, everybody. Welcome, everyone. Thank you for joining us for today's presentation. My name is Shafak Erdem, and today I will be presenting on the Export Administration Regulations of the United States. Today we will cover some issues which mainly includes an overview of the ER regulations with the definitions and the understanding of it, and steps for using the ER, general prohibitions, commerce control list, license exceptions, control policies, CCL-based and end-user and end-use-based control policies, embargoes and other special controls, and lastly, we will mention about the penalties. Before I start my presentation, I would like to remind you that this is not an legal advice for anyone that is doing any custom or international trade business, and the communication and of this of information through this presentation is not provided in the course of or does not create any attorney-client relationship. There are some terms in the ER that we need to know. First, let's have a look on the prominent definitions under the ER. For example, the U.S. person. Who is U.S. person? Many people can think about that the U.S. person is then only an individual. No, it's a very broad term, and an individual who is a citizen of the United States, a permanent resident alien of the United States, or a protected individual. An entity organized under the laws of the United States or any jurisdiction within the United States, including foreign branches, and any person physically located in the United States. What are covered under the ER are we call them the items, and the items are also very broad. They are commodities, software, and the technology. When the ER intend to refer specifically to commodities, software, or technology, the text will use the specific reference. Export, the term export is under the Export Administration Regulations. It refers to the sending or taking of goods or technologies out of the United States to a foreign country, or the release of technology or software to a foreign national within the United States. This may include the activities such as shipping goods to a foreign country, sending goods by mail or courier to a foreign country, transferring goods to a foreign national within the United States, or disclosing technology or software to a foreign national within the United States, and making goods or technologies available to a foreign national within the United States. And exports may may be made by any means, including by land, sea, or air, and may include the transfer of goods or technologies by electronic means, such as via the internet or email. And the other term which is crucial for us is the re-export. The term re-export refers to sending or taking of goods or technologies that were originally reported from the United States to a foreign country to another country. But re-exports also include the release of technology or software to a foreign national outside the United States. The ER also regulates the export and the re-export of goods and technologies that are subject to ER by virtue of their incorporation into other goods. This means that the ER may apply to the export or re-export of goods that contain controlled components or materials, even if the controlled items make up only a small portion of the finished good. Who is exporter? The person in the United States who has the authority of a principal party in interest to determine and control the sending of items out of the United States. And the other term, end user, is the person abroad that receives and ultimately uses the exported or re-exported item. The end user is not a forwarding agent or intermediary, but maybe the purchaser or the ultimate consignee. In other words, the end user is the ultimate destination of the goods or technologies and is responsible for using them for their intended purposes. Uh, just to give you some example about the activities that are not exports, re-exports, or transfers. For example, launching a spacecraft or other item into space. It's not an export. Transferring technology or software to a person in the United States who is not a foreign person from another person in the United States. Another example is that is generally allowed to transfer technology or software within the same country to persons who are not foreign persons, as long as the transfer does not result in a release of technology or software to a foreign person or to a person prohibited from receiving it. There are some terms and abbreviations that you need to be very familiar in the ER, which is shown on the slide. For example, the BIS, Bureau of Industry and Security, CCL, Commerce Control List, and the rest. Export controls restrict the movement of certain items and information to certain persons and destinations in order to serve the national security and the foreign policy interests of a particular country. So US export controls are designed to restrict countries or persons from accessing certain items, information to prevent items and information from being used in a way that is contrary to the interests of the United States. Export controls may be unilateral, but are often driven by multilateral export control regimes, which may include the Wassenaar Arrangement, Nuclear Suppliers Group, Australia Group, Missile Technology Group Control Regime, and Zagner Committee. Uh, Here are the three agencies that you need to know, the three major US export control regulatory and licensing agencies, the enacted legislation for each agency and their regulations and scope. There are some additional agencies that have other various or unique roles in supporting or enforcing US export control laws. But the primary one for the military is the DTC, the Department of State, uh, the Department of State Director of Defense and Trade Controls. BIS is responsible for the dual use items and for ER, the Department of the Commerce, Bureau of Industry and Security, and the OFAC for the sanctions scheme. Let's have a look into the steps to be followed for using the ER. There are some facts about the transaction. The five types of facts to help to determine the obligations under the ER is: what is it, where is it going, who will receive it, what will they do with it, what else do they do. So what is it means, what an item is for export control purposes? It depends on its classification, which is its place on the commerce control lists. Where is it going is the country of ultimate destination for an export or re-export also determines licensing requirements. And who will receive it, the ultimate end user of the item cannot be a restricted end user. What will they do with it? With it is like the end user, the ultimate end user of the item cannot be a restricted end use. And what do they do with it? It's a conduct such as contracting, financing, and freight forwarding, and a support of a proliferation project may prevent dealing with the party. Uh, the question, are the items and the activities subject to the AR? In response to that questions, first it should be determined whether a commodity, software, or technology is subject to ER, and its steps 1 through steps 6 helps to understand this. If an item is determined to be subject to ER, next the 10 general provisions should be considered. We'll talk about these general provisions in greater detail in the following slides of our presentation. Uh, the question is the question that is a license exception available to overcome the license requirement if by reviewing the CCL, the commerce control list, in combination with the country chart, it is determined that a license is required for the destination, whether a license exception will be applicable to that requirement. The steps 20 through 24 helps determine whether a license exception is available. And how do you apply for a license? If a license application is required to be submitted, application requirements should be reviewed as suggested by step 26, as well as additional requirements such as declarations and record keeping and requirements. Uh, let's have a look into the steps to be followed for using the ER. Oh, sorry. Yes. As we have previously seen, the first 6 steps are about determining if an item is subject to ER. And the item subject to the exclusive, the step 1, jurisdiction of another federal agency. This step is relevant for both exports and re-exports. It's important to determine whether an item is subject to the exclusive jurisdiction of another federal agency other than BIS. If item is subject to the exclusive jurisdiction of another federal agency, the regulations of that agency must be complied with, and ER compliance is not required. If item is not subject to the exclusive jurisdiction of another federal agency, then other steps should be followed to determine the ER's applicability. The step 2 is the publicly available technology and software. This step is relevant for both exports and the re-exports. It's about determining if technology or software is publicly available as defined and explained in the ER. Step 3 is re-export of a US origin item. This step is appropriate only for re-exporters. And for an item in a foreign country, whether the item is a US origin should be determined. Step 4 is foreign-made items incorporating controlled US origin items. This step is appropriate only for items that are made outside the United States and not currently located in the United States. Special requirements and the restrictions apply to foreign-made items that incorporate the US origin encryption items. There is currently no step 5, and there is step 6, the direct product rule. The direct product rule is the foreign items that are the direct product of US technology, software, or plant, or a major component of a plant made from US technology or software, which may be subject to ER. If they meet the conditions of general provisions, general provision 3. So direct product rule is direct products that are subject to the ER may require a license to be exported from abroad or re-exported to certain countries. I know it's a little complicated, but each step gives a guidance for better understanding in the ER. Step 7 through 19 are concerning the 10 general provisions. Step 7 is the classification, and the items should be classified as subject to ER in the relevant entry on the CCL. The CCL includes a supplement called Commerce Control List Order of Review. This supplement establishes the steps or the order of review that should be followed in classifying items that are subject to ER. The exporter, re-exporter, or transferer is responsible for correctly classifying the items in a transaction, which may involve submitting a classification request to BIS. Failure to classify or have classified the item correctly does not relieve the person of the obligation to obtain a license when one is required by ER. It is also possible to request the applicable classification of the item from BIS, and BIS has a duty to provide the correct classification upon request. For items subject to the ER but not listed on the CCL, the proper classification is ER99. This number is a basket for items not specified under any CCL entry and appears at the end of each category on the CCL list. Step 8 is the country of ultimate destination, and the country of ultimate destination should be determined, which determines the applicability of several general provisions, license exceptions, and other requirements. Step 9, the reason for control and the country chart. Once it's determined that an item is controlled by a specific ECCN, information contained in the license requirements section of that ECCN in combination with the country chart should be used to decide whether a license is required under general provisions 1, 2, or 3 to a particular destination. Step 10. Step 10 is Step 10 is foreign-made items incorporated and controlled, U.S. origin items, and the de minimis rule. As a broad explanation, the de minimis rule determine if a foreign-made item is subject to U.S. controls due to its U.S. origin parts. If a foreign-made item abroad is a foreign-made commodity that incorporates controlled U.S. origin commodities, is bundled with the controlled US origin software, or is a software that is commingled with the controlled US origin software, or a technology that is combined with the controlled US origin technology, then it's subject to the ER. And if the United States origin control content exceeds the de minimis levels, it is 25% of the product. For some countries, it's 10%. Step 11 is the foreign produced direct product rules, and which general provision 3. The foreign produced items located outside the US that are the direct product of the technology of software subject to the ER or produced by a plant or major component of a plant located outside the United States that's a direct product of a US origin technology or software subject to the ER. Whether they are made in the United States or a foreign country, they may be subject to the ER if they meet the conditions of General Provision 3. Step 12 is the person's denied export privilege. It should be determined whether the transferee, ultimate end user, and any intermediate consignee or any other party to a transaction is a person denied export privileges. Step 13, the prohibited end users and the end users. The end users and the end users prohibited under General Provision 5 should be reviewed against the intended transactions. Step 14 is the embargoed countries and special designations. If the destination, for example, for any item is an embargoed destination such as Cuba, Iran, Iraq, North Korea, or Syria, the relevant requirements must be considered. Unless otherwise indicated, General Provision 6, the embargoes applies to all items subject to the ER. Restrictions on specific activities of a U.S. person is a step 15. As we have previously mentioned, the definition of a U.S. person in the ER is important, and this definition, along with the scope of the activity prohibited by General Provision 7, should be reviewed. In transit, step 16, the shippers and the operators of vessels or aircraft should review General Provision 8 in transit to determine the countries in which they may not unladen or ship certain items in transit. General Provision 8 applies to all items subject to ER. Step 17, review orders and terms and the conditions. The orders, the terms, and the conditions applicable to the transaction should be reviewed. General Provision 9 applies to this step, and it prohibits to the violation of any other terms and the conditions imposed under the ER. Step 18 is the review of the Know Your Customer. It's the guidance and the General Provision 10 also in the same time. The license requirements under the ER are determined solely by the classification, end user, ultimate destination, and conduct of a U.S. person. And General Provision 10 prohibits anyone from proceeding with a transaction with knowledge that a violation of AR has occurred or is about to occur. It also prohibits related shipping, financing, and other services, and the General Provision 10 applies all items subject to ER. Step 19, it's a complete review of the General Provision. After completion of the steps regarding the general provisions and the review of all 10 general provisions, including cross-reference regulations in the ER, it will become clear which, if any, of the 10 general provisions of the ER apply to the contemplated transaction or activity. Step 20 is the applicability of the general provisions. In step 20, it should be determined if any of the general provisions described in the ER apply to the subject export or re-export. And step 21 is the applicability of the restrictions on all license exceptions. In step 21, it should be determined if any restrictions in the ER apply to export and re-export transactions. Step 22 is the terms and the conditions of the license exceptions. If none of the restrictions in the ER applies, in step 22, each of the license exceptions should be reviewed to see if any of them authorize the export and the re-export. Step 23 is the scope of the license exceptions. In step 23, any country or item-specific limitations on the license exceptions should be considered. In step 24, it's compliance with all terms and the conditions. And if a license exception is available, it should be ensured that all its required terms and the conditions are met to proceed with the export or re-export. Step 25 is the license requirements. If no license exception is available in step 25, a license should be obtained or a proposed export or re-export should be refrained from. Step 26, a license. In step 26, if a license application is to be submitted to the Bureau of Industry and Security, the BIS, the requirements, instructions, and the required documents for applications in the ER should be reviewed prior to submitting the applications. In step 27, it's electronic export information filing requirements. The exporters or agents authorized to file electronic export information to the automated export system should review the ER to determine whether EEI is required to be filed and what data elements needs to be included. In 28, step 28, the destination control statement, it should be entered on the invoice and on the shipping documents for the shipment from the United States to the ultimate consignee or end user abroad. The person responsible for preparing these documents is responsible for entering the DCS. And the 29th, the record keeping, according to step 29, the records of transactions subject to ER should be maintained for 5 years in accordance with the record keeping provisions of the ER. So as you all see, there are too many issues and the too many steps in using the ER. And let's move on to the general provisions under the ER. Then a person may undertake the transactions subject to ER without a license or other authorization unless the regulations affirmatively state such a requirement. As such, if an export, re-export, or activity is subject to ER, the general provisions and the license exceptions must be reviewed to determine if a license is necessary. The 10 general provisions describe certain exports, re-exports, in-country transfers, and other conduct subject to the scope of the ER, in which a person may not engage unless they either have a license from the BIS or a qualified or qualify for a license exception. If an item or activity is subject to the scope of the ER, each of the 10 general provisions should be considered to determine whether any of the provisions are applicable. In case any of the general provisions determined under the ER are violated or any conduct contrary to the ER or any order, license exception, or authorization issued thereunder is conducted, then the sanctions may apply. Now let's have a more detailed look at the general provisions. As mentioned, the first three provisions are the item controls that are shaped and limited by the parameters specified on the CCL and the country charts. The general provision one is concerning the export and the re-export of controlled items to listed countries that states that is prohibited to export and any item subject to ER to another country or re-export of any item of US origin without a license or license exception. This provision applies if the item is controlled for a certain reason, as indicated in the export control classification number, which is ECCN, and the exporting the item to the destination country requires a license for that specific reason, as indicated on the country chart. General provision 2 concerning US content re-exports, which states that it's prohibited to re-export or export from abroad foreign-made items that incorporate more than a de minimis amount of controlled US content. This provision is applicable if the item incorporates more than the de minimis amount of controlled US content as defined in the ER, and the item is controlled for a certain reason as indicated in the applicable ECCN, or exporting the item to the destination country requires a license for that specific reason as indicated on the country charts. The general provision 3 is regarding the foreign direct products, and it stipulates that it's generally prohibited to export from abroad, re-export, or transfer in country foreign-made items that are subject to the ER, which are known as foreign direct products, if the item is subject to a license requirements in the ER. The scope of these provisions depend on the classification of the item and the ultimate destination, as that combination is reflected on the country chart. Still, if all the terms and the conditions of a licensing exceptions are met, then export or re-export of controlled item without getting a license will be possible. General provisions 4 through 10 are the provisions on certain activities that are not allowed without authorization from BIS. And these provisions apply to all items subject to ER unless otherwise specified. According to general provision regarding Daniel orders, it's not allowed to take any action that is prohibited by a Daniel. Daniel orders prohibit many actions in addition to direct exports by the person denied export privileges, including some transfers within a single country, either in the United States or abroad, by other persons. It is the responsibility of the individual to ensure that any transactions that are involved in do not violate the terms of the order if a person who has not been denied export privilege is also involved. Orders denying export privileges are published in the Federal Register when they are issued and are legally controlling documents in accordance with their terms. BIS also maintains compilations of persons denied export privileges on its website. And additionally, BIS may, on exceptional basis, authorize activity otherwise prohibited by a denial order. There are no license exceptions under the EAR that authorize conduct prohibited by the General Provision 4. And the General Provision 5 states that it's prohibited to knowingly export, re-export, or transfer in country any item subject to the ER to an end user or an end use that's prohibited by the ER without a license. Each section under the end user and the end use control policies specify whether the license requirements extend to exports, re-export, and the transfers in the country. General Provision 6 concerning the re-exports, exports, and the transfer to embargoed destinations requires that such activities transferring any items regulated by the ER to a country or region that is embargoed by the United States or subject to controls under the ER is not allowed unless a specific license or exception is obtained. Each section under the embargoes and the other special controlled parts of the ER specifies whether the license requirements extend to re-export, export, and transfers in country, unless otherwise authorized in the part regarding the embargoes. The license exceptions of the ER do not apply to these provisions. General Provision 7, it concerns the support of proliferation activities and certain military intelligence end users and end users by U.S. persons. Uh, it prohibits certain activities related to proliferation and the military intelligence by U.S. persons as defined in the ER. And without a license from the BIS, U.S. persons are not allowed to engage in activities such as shipping, transmitting, or transferring items not regulated by the ER to support the design, development, production, operation, installation, maintenance, repair, overhaul, or refurbishing of nuclear explosive devices in certain countries, missiles in certain countries, chemical or biological weapons worldwide, or all plans to make a chemical weapons precursors in certain countries. U.S. persons are also not allowed to re-export Schedule 1 chemicals listed in the ER to certain destinations without first complying with the certain provisions, or to export Schedule 3 chemicals to certain destinations without complying with end-use certificate requirements. Additionally, U.S. persons are also prohibited from engaging in any contract service or employment related to these activities that they know or are informed by BIS that will support military intelligence and users or end users in certain countries. General Provision 8 is regarding the in transit. It prohibits exporting or re-exporting of items through or transiting through certain countries, unless a specific license or exception allows for it, or the export or re-export is eligible without a license. These countries are Armenia, Azerbaijan, Belarus, Cambodia, Cuba, Georgia, Kazakhstan, Kyrgyzstan, Laos, Russia, Tajikistan, Uzbekistan, Vietnam, and there are some other countries which I do not remember now. The General Prohibition 9, it prohibits violating the terms and the conditions of a license or license exception issued under the ER, or violating any orders issued under the ER. There are no exceptions to this prohibition, which is important. The General Prohibition 10 regarding the knowledge violation to occur, it prohibits conducting transactions with knowledge that a violation of the ER, the Export Control Reform Act of 2018, or any related orders, licenses, or exceptions has occurred, is about to occur, or is intended to occur in connection with the item being exported, re-exported, or transferred. It also prohibits relying on a license or exception after being notified of its suspension or revocation. There are no license exceptions to these prohibitions as well. In the commerce control list, there are categories, there are groups and the entries, and this list is a list of the items that are subject to export controls under the ER, and it is used to identify the specific controls that apply to the item. However, the CCL includes items subject to the Export Licensing Authority of BIS and does not include those items exclusively controlled for export or re-export by another department or agency of the US government. In instances where agencies other than the Department of Commerce administer controls over related items, the entries in the CCL contain a reference to these controls. It's important to note that the CCL is not an exhaustive list of all controlled items, as some items may be controlled for reasons other than those listed in the CCL. The CCL categorizes the items into different control categories, which are based on the item's specific characteristics, such as its technical capabilities, potential end use, and the potential end user. Each category is further divided into 5 product groups, and the list categorizes items into control categories based on their characteristics, such as technical capabilities, potential end use, and the potential end users. These categories are further divided into product groups, and there are 10 categories in the CCL: nuclear materials, and the facilities, and the equipment, and the others as shown on the presentation. Within each category, items are arranged into 5 groups that are equipment, assemblies, and components, test, inspection, and production equipment, materials, software, and technology. Export classification, control classification number, which is ECCN, are used to identify dual-use items on the commerce control list for export control purposes. All ECCNs are listed in the CCL based on their nature and the technical capabilities. And it's important to note that the ECCNs are different from Schedule B numbers, which are used for trade statistics and the harmonized tariff system nomenclature, which determines import duties. So it's not the HS codes. ECCN is particular for and special for the US export control regime. The first character of the ECCN identifies the category, and the second character of the ECCN identifies the product group of an item. The third character differentiates entries by identifying the type of controls associated with the items that which I will be explaining shortly. If an item falls under the U.S. Department of Commerce jurisdiction but is not listed on the CCL, it is designated as ER99. ER99 items are generally low technology consumer goods that do not typically require a license, but a license may be required if the item is being exported to an embargoed country, to an end user of concern, or in support of a prohibited end use. Let's also mention how to read ECCN. And ECCN is made up of four sections: the heading, license requirements, license exceptions, and the list of the controlled items. In the heading section, a description of the items controlled is provided. The license requirements section has two columns: controls, which identifies all applicable reasons for control, and the country chart, which identifies the countries requiring a license for each reason for control. The license exceptions section provides eligibility statements for each ECCN-driven license exception that may be applicable. The list of the items controlled section may include various subsections, such as a related definition subsection, a related control subsection, and an item subsection. The related definition subsection provides definitions and or the parameters that apply to all items controlled by the entry. The related control subsection includes information on whether another U.S. government agency or department has export licensing authority over the items related to those controlled by the entry. And the item subsections describes the relationship between the items paragraph and the ECCN headings, and helping the users to classify the items on the CCL list. Uh, the several military-related items were transferred from state to commerce, and those are captured in the 600 series ECCNs and 9515 as described on the slide. Here is an example of 2B231 vacuum pump entry on the CCL and the reasons for control, what license exceptions apply, and the technical specs for the items listed. You can see how the items is described in the specific technical terms to assist in determining if your item is captured in a specific CCL entry. As we have just mentioned, the reasons for control associated with an item can be identified by the third character of its ECCN. The reason for control could include the national security, including the dual use and the Wassenaar arrangement munition list, and items on the NSG dual use annex and trigger lists, missile technology, nuclear non-proliferation, chemical, biological weapons, and items warranting the national security or foreign policy controls at the determination of the Department of Commerce, and the items on the Wassenaar Arrangement munitions list, or formerly on the U.S. munitions list, USML, and the anti-terrorism, crime control, regional stability, short supply, and the UN sanctions lists. Let's move on to the use of the country chart to determine if a license is required to export an item to a particular destination. It's necessary to use information from the ECCN and the country chart. As I mentioned, the applicable ECCN would indicate the reasons for control for items within that ECCN, and the country chart should then be consulted to locate the correct column identifier. If there is an X in the cell next to the destination in question, it means that the license is required unless a license exception applies. If there is no X in the relevant column, a license is not required. However, it's still necessary to check for additional controls that might apply under the ER. It's also important to note that there are some other exceptions to this process, such as items controlled for short supply reasons and items subject to the embargo or other special control provisions. For destinations subject to embargo or special control provisions, such as Cuba, Iran, North Korea, and Syria, the relevant part of the ER should be referred to. For Iraq and Russia, the country chart, for example, provides that for certain license requirements and else, and there are additional requirements under the ER that should be referred to. It's important to note that the state C through rule and how any amount of U.S. origin, U.S. ML content, U.S. munition list content into a product will entail the entire end product being under the jurisdictions of states, ITAR, international traffic and arms regulations. The R is little different as noted, and the incorporated item in an ER controlled item takes on the control of the overall entire item. Excuse me. We also need to note that the related software or the technology can also be controlled under a related ECCN on the commerce control list. And there are three basic ways to obtain the ECCN for the items in your transaction. Have the manufacturer or your supplier provide the classification. Make sure you verify as well, and the self-classify using your own technical experts, or request a formal classification. Be sending a request to commerce, then the BIS. And here are and here are the 10 categories of items, including on the commerce control list CC. In the US, export controls are primarily list-based, meaning that the items that the US wants to control for exports are specifically and technically described and listed on one of the two primary export control lists that are regulated by the US Commerce Department or the State Departments. And let's have a look on the license exceptions. A license exception is an authorization which allows export or re-export under certain conditions an item subject to ER that would otherwise require a license. To review a license exception eligibility under the general provisions, if an export or re-export is subject to the ER, a license exception may be applicable to the items that would otherwise require a license under general provision 1, 2, 3, or 8. If an export or re-export is subject to general provision 4, 7, 9, or 10, there are no license exceptions available. If an export is subject to general provisions 5 or general provision 6, license exceptions may be applicable with the specific conditions under the relevant sections. If the license application exceptions can be used for an export or re-export, any restrictions on license application exceptions should be determined, and a number of the restrictions may apply, such as suspension or revocation of authorization to use a license exception, or the destination of the export or re-export being a sanctioned destination. If any restriction applies, no license exception may be used for that transaction. If none of the restrictions to license exceptions applies, then each license exception should be reviewed to determine if any of them authorizes the export or re-export. Eligibility for license exceptions may be based on the item, the country of ultimate destination, the end use and the end user, along with any special conditions imposed within a specific license exceptions. Conditions for more than one license exception may be met at the same time, and any license exception available to the specific situation may be used, and it's not then required to use the most restrictive applicable license exception. An important point to note is that some license exceptions are limited by country or by type of the item. Countries are arranged in country groups, and these groups are referenced in under license exceptions when necessary. If an export or re-export is subject to General Prohibition 6, which is embargo, and or the export and re-export to embargo destinations, then the license exceptions are only available to the extent specifically provided in the ER for these destinations. ER license exceptions or exemptions in the ITAR and the general licenses at the OFAC are very useful because they eliminate the need to apply for and obtain a license. When you use a license exception, you are certifying that the all terms and the conditions of that exceptions have been met. Yes. For export control purposes, the ER separates foreign countries into groups designated by the above letters. These designations are important when determining if the shipment is eligible for a license exception, as these are mainly dependent on the ultimate destination's countries group. So the license exceptions as shown on the slide are based on the ECCN of the item being shipped. You still need to confirm there are no general restrictions, but if not, then the ECCN entry itself will inform you whether a license exception is available. GBS shipments to Group B countries is available only the country Group B, only the countries in the Group B. LVS covers shipments of a specific lower value, and that value is marked on each ECCN entry. TSR covers the shipment of some specific software or technologies, but a written letter of assurance is required from the customer prior to export. And STA is a never license exception that allows for certain ECCNs or portions of an ECCN to be shipped to certain authorized countries. And this license exception also requires a statement from the customer prior to the export. Depending on your customer's country and the typical items shipped, you might want to review these license exceptions to confirm which might be most useful and authorize some of your exports. And those on the slides show the transaction-based license exceptions. TMP covers export or re-export that will only be for a temporary basis, such as for a trade show demo. RPL covers one replacement of parts or servicing and repair as long as no enhancements are made. TSU covers operation technology and software, sales technology and software updates like bug fixes. Again, for all of these license exceptions, it's critical to review each one closely to ensure your shipment is authorized by the license applications. And the control policies, CCL-based controls, as I have previously explained, the CCL is a list of the items that are subject to export control regulations under the ER, and the CCL policies specify the controls that applies to export, re-export, and transfer of the items on the CCL list. The purpose of the CCL-based control policies is to ensure that the export of controlled goods and the technologies are consistent with the U.S. national security. and the foreign policy interests. And the CCL-based control policies are designed to regulate the export of the items that have potential military or proliferation applications. These items may include certain technologies, software, and the equipment that are subject to export controls due to their potential use in the development, production, or the use of weapons of mass destructions. And ER establish different levels of controls for different types of goods and the technologies based on their level of sensitivity. For example, some goods and the technologies may be subject to more stringent controls because they have a higher potential for military use or because they are particularly sensitive for other reasons. Uh, there are several different types of control policies that can apply to the items on the CCL. Depending on the nature of the item and its intended use. These control policies are based on various national security and foreign policy and the other considerations. Just to give you an example of the policies that may apply to the items on the CCL, it's national security controls, missile technology controls, anti-terrorism, and the regional stability. The national security controls designated to protect U.S. national security interests, and the missile technology controls designated to prevent the proliferation of missiles and the related technologies. There are many other control policies that might apply to the items on the CCL, and the specific controls that apply to a particular item will depend on the nature of that item and its intended use. In case of overlapping policies for an item, license applications are reviewed under all applicable licensing policies, and the license is issued only if an application can be approved under all applicable licensing policies. The CCL-based control policies also establish specific conditions that must be met in order for a company to obtain a license or other authorization to export controlled goods and the technologies. These conditions may include requirements related to the end use of the goods or the technologies, the end user of the goods or the technologies, and the country to which the goods or the technologies will be exported. For example, as an end-use restriction, the ER may require certain controls be placed on the use or re-export of the goods or the technologies once they have been exported. The ER may also require that a license be obtained before exporting controlled goods or the technologies to certain individuals or the entities, such as terrorists or the proliferators of weapons of mass destruction. And as a destination restriction, the ER may require that a license be obtained before exporting a controlled good or a technology to specific countries. These are just a few examples of the types of the conditions that may be established in the ER for obtaining a license or other authorizations to export controlled goods and the technologies. There are many other types of conditions that may apply depending on the specific goods or the technologies being exported and the country to which they are being exported. Uh, skip the other slide. And for the control policies which are related to end use and the end user based controls, the ER established restrictions on the export, re-export, and the foreign transfer of goods and technologies to certain countries, regions, or individuals based on the identity of the end user and the intended use. End user controls are measures that restrict the good export of goods and the technologies to certain individuals or entities based on their identity. For example, the ER may prohibit the export of certain goods or technologies to individuals or entities that are known to be involved in the activities that are harmful to the US national security and foreign policy interests, such as terrorists or proliferations of the mass destruction. End-use controls are measures that restrict the export of the goods and the technologies based on the intended end use of the goods or the technologies. For example, the ER may prohibit the export of certain goods or technologies to countries that are subject to the US arms and embargoes or the sanctions that are known to be involved in activities that are harmful to US national security and their foreign policy interests.
All right, Mr. Sapak, I'm sorry to interrupt. We already have an hour for this presentation. I'll let you finish. So we'll extend for about 5 to 8 minutes. We'll just let the speaker finish the presentation. Go ahead, sir.
Thank you very much. And then we can go embargoes and the other specific special controls. And our my last point is the embargoes and the specific special control section of the ER. Embargoes are restrictions on the export, re-export, and the transfers in the country of items to specific countries or regions. Other special controls refer to measures that are put in place in addition to the standard controls that apply to items on the commerce control lists. There are several reasons why the US government may impose embargoes and other special controls on the export of certain items. Some examples include the national security concerns, some are foreign policy considerations, human rights concerns, and the sanctions by the OFAC. There are mainly two categories of the controls. These are comprehensive controls and the sanctions on the selected categories of the items of the specific destinations. And the comprehensive controls apply to countries that are subject to general embargoes or comprehensive sanctions, such as Cuba, Iran, and Syria. So I can end my presentation, Ron.
All right. Thank you so much for that very informative presentation. So I can open for a few questions right now. I'm seeing few questions here. But before that, before we proceed, I would like to remind everyone that this webinar is recorded and it will be uploaded to our YouTube channel. Just search International Trade Council, or you can replay the recording here in Air Meet. Also, please expect you will receive the certificate of participation in the next days for attending for this webinar. And if anyone in the group that is not yet a member of International Trade Council, please feel free to email me and we can offer you free membership. So we have one question here from Lisa. I'll just show the question here. Under your general prohibition step 4, where foreign items are controlled and in collaboration with step 7, how do you determine whether or not an item can or cannot be exported to the United States? Is there a formula?
I don't know the answer. There is no formula that the item should be reported whether it will be re-exported or exported.
Okay. And next question here. The term limited value shipment, is there a price ceiling or something other or some other ceiling which warrants this?
Yeah, there is a price ceiling about that. Every year they announce it.
Okay. Thank you. So sir, I would suggest you type in your email address. Oh, your email address is showing on the screen. So if you have more questions, please feel free to email him directly. And again, if you would like to review the recording, please feel free to visit our YouTube channel. Before we end this session, I would like to ask our speaker to give his final words. Anything that you would like to add before we end our presentation?
I would like to thank you for the International Trade Council and all the participants to join us today in this very insightful webinar. I hope it continues to have a better understanding on the international trade developments. Thank you very much, Ron.
Thank you, sir. You're welcome. All right. On behalf of International Trade Council, I'd like to extend our sincere thanks to our speaker for sharing their valuable insights on U.S. export administration regulations and compliance practices. We also would like to thank each of you for being here today, and we hope the strategies, best practices, and case studies discussed will empower you to navigate the complexities of export controls with greater confidence and build a strong compliance culture with your organization. We appreciate your engagement and look forward seeing you to our future events. Thank you, and you have a wonderful day.
Thank you
Bye,
very
guys.
much.